Good evening, everyone. My name is Wade Hinton. I'm the CEO and founder of Hinton Company, an advisory firm headquartered here in Chattanooga. And I'm going to be your moderator for tonight. Welcome to the first Tennessee Democracy Forum's conversation on democracy of the 2023 season. Over the next hour, we will speak with Robyn Sanders and Andrew Garber, attorneys and authors of the Brennan Center for Justice's recent article, The Unconstitutional Expulsion of Legislators. Before we get to our speakers, some quick ground rules for tonight. We want this to be an engaging conversation, so we are asking you to provide questions throughout the program. Now, you can submit your questions by going to the Q&A button at the very bottom of your screen. We're going to reserve time for those questions at the end of the presentation. However, if there are questions that are relevant to a particular topic that a speaker is presenting, we'll try to weave those into the conversation. So let me get a chance to introduce our fantastic panelists. I'm excited to have this conversation with them this evening. First is Robyn Sanders. Robyn is counsel with democracy programs with the Brennan Center's Democracy Programs Voting Rights and Elections team. She focuses on voting rights, litigation, and policy advocacy. Sanders previously served as the judicial law clerk to the Honorable Associate Judge Justice Anita Earls of the North Carolina Supreme Court. Now, Sanders earned her JD from Campbell University's Norman Adrian Wiggins School of Law, where she served as an editor of the Campbell Law Observer. Before attending law school, Robyn worked as a policy analyst for the North Carolina Department of Public Safety. During her time there, she focused on issues related to prison safety and security reform, juvenile justice reform, and was a policy advisor and aide for Governor Roy Cooper's reentry council. Sanders also received a master's degree with high honors in public administration from North Carolina State University and an LLM with distinction in international legal studies from Nottingham Trent University in England. She earned a bachelor's degree in political science at North Carolina State University. So welcome, Robyn. Thank you so much. Good to be here with you.
Thank you.
Andrew Garber is counsel with Brennan Center's for Justice's Department of Democracy Programs Voting Rights and Election team as well. Prior to joining Brennan, he was a litigation associate at Simpson, Thacher, and Bartlett, where he focused on commercial litigation along with a wide range of pro bono matters. He's a graduate of Columbia Law School, where he was a Harlan Fiske Stone Scholar and served as an articles editor to the Journal of Law and Social Programs. I'm going to say Harlan Fiske Stone Scholar 3 times fast and see what happens. Really. But during law school, he was also a clerk to Senator Chris Coons on the Senate Judiciary Committee, and intern to Judge Paul Gardep in the Southern District of New York, and an intern in the bill drafting unit of the New York City Council's Legislative Department. Andrew holds an BA in political science from Villanova University. So again, I'm excited to have this conversation with you here in Tennessee. First, as we get started with this conversation, I do want to say this at the outset. When we hear these conversations about the topic of these expulsions, at times it can get very political. It can get partisan, in fact. That's not what we're here for tonight. We want to have a conversation on the facts and the legal analysis that's been conducted by our 2 experts here tonight. That doesn't mean we can't talk about politics because of everything that has happened, but I wanted to make sure that we're clear in how our approach is for this evening. So Andrew, I want to start with you, right? For those in the audience who have not had a chance to read your article, would you provide a bit of background on your findings around this particular case or this issue, and any arguments that you presented in the article?
Absolutely. And thank you, Wade. Really excited to be here with you. And thank you to the Tennessee Democracy Forum for having us. We're really excited for this conversation as well. So we wanted to write this piece for a couple of reasons. And one of the main ones was just kind of at a core level when these expulsions and the near expulsion happened. It was my own feeling, I think from talking with Robyn, it was her feeling as well. And you kind of got the sense from hearing a lot of the media attention, it felt like something was wrong. But a lot of people were having trouble putting into words what exactly was wrong. You know, it felt like there might have been some discrimination here. It felt like the majority had perhaps gone too far, but it was hard to articulate whether they had done something that was truly out of the norm, or perhaps violated the law in any way. And so we were really interested in digging into those questions and determining, in fact, whether there was something from a legal perspective and from a historical perspective that was wrong that the majority should not have done. And the second real key reason we wanted to write this is not an isolated incident. We are seeing across the country a number of majoritarian abuses of power, and they take some different forms. For example, in Wisconsin, legislators were threatening to impeach the winner of an election to sit on the Wisconsin Supreme Court before that winner even took her seat. In Florida, the governor fired an elected county prosecutor because he disagreed with that prosecutor's charging decisions. These are not isolated incidents. They are not truly different from each other. They go hand in hand of instances where the people's representatives are having their power taken away because they're promoting positions the majority doesn't like, or they're the people the majority doesn't want in those positions, or perhaps I should say those in power. It's not always the legislative majority. And so we thought it was really important to articulate that and to be able to name and demonstrate that this is a growing problem. And while it can take different forms, the expulsions in the Tennessee legislature was in a particularly egregious example. So our piece makes two key arguments. I'm going to talk about the first, and then I'll hand it off to Robyn for the second. The first is that these expulsions and why they happen were really unprecedented. We did a lot of research to find every instance we could of a legislator who was kicked out of either Congress or a state legislature in the history of our country. We found 122 total instances of state legislatures doing this, 20 members have been kicked out of Congress. Overwhelmingly, almost all of them was because they committed a crime. They were convicted of a crime, usually something related to bribery, fraud, something that really bears directly in their office. Or it might be that there was credible allegations, an investigation was undertook that demonstrated they had committed sexual assault, sexual harassment, something like that, that's just not fit for any workplace. As well as there were a number of instances of treason, where members of Congress, either related to the Confederacy or someone in a state legislature, happily conspiring with foreign powers. Those are all good reasons, we believe, to remove someone from a legislature. If people are committing crimes, if they are committing treason, we can't trust them to represent us. There were a very small number of instances we found where members were removed because of their views. And the most recent one was over 100 years ago. The last time it happened, the New York State Legislature kicked out a few members because they were members of the Socialist Party. And putting aside anyone's views on socialism or the Socialist Party, the fact that they were considered unfit to serve by their colleagues is something that I think we as a country look back on with a lot of shame. They had every right to promote those views, and if the people elected and promote those views, they should have been able to do so. So the fact that the representatives Pearson and Jones were removed from the legislature because they wanted to talk about gun control reform and really put forth their views on behalf of the constituents and do so strongly was really unprecedented. We have to go back to an entirely different era to see anything like it.
Robyn? We are on mute. You're saying something brilliant right now.
Thank you so much for the kind introduction, and I'm also very happy to be here to talk about this very important topic. As Andrew was stating, the other reason why we wanted to write this piece was to explore the broader consequences of it and to explore the legal implications of what happened in Tennessee. And so we pivot our research from historical context to exploring whether or not the Constitution prohibits the kind of actions that the supermajority took here against Representatives Pearson and Jones. And so what we did was we looked at some United States Supreme Court cases that explored similar concepts to expulsion, and also just talked about broad principles that the courts have applied to situations like this related to equality and discrimination. And what we found was that when we applied the facts to the particular cases and the principles that were illustrated in those cases, we determined that we think what happened here was not only wrong, like Andrew said, and historically unprecedented, but also likely violated multiple provisions of the Constitution. The first conclusion that we reached was that we think that the expulsions likely violated the First Amendment, because the First Amendment prohibits the government from restricting speech and restricting the ability of people to say what they want based on their views and the content of that speech. The other violation that we think likely occurred here was a violation of the 14th Amendment's Equal Protection Clause, which guarantees that people will be treated, equally and fairly who are similarly situated. And it also prohibits racial discrimination, intentional racial discrimination by state actors. And what we found here was that when applying an evidentiary framework called the Arlington Heights test that the court has adopted to determine whether an action is discriminatory, that it appears here that those actions by the Republican supermajority indeed were intentionally racially discriminatory, even if on the surface it appears that it wasn't. And as we will talk about later, because Representative Johnson was able to survive the expulsion vote, and she is a white representative, and Representatives Pearson and Jones, who are both African-American men, did not. That was one of the main factors that we assessed in looking at the racial discriminatory aspect of what happened. And then finally, we also concluded that we think that the actions likely violated the 15th Amendment to the Constitution, which prohibits discrimination in discriminating against African-Americans or people of color on the basis of their race in voting. And what we came away with was that not only does that guarantee equal access to the ballot, but it also guarantees equal political representation. And we think that the actions of the legislature not only violated the rights likely of the representatives themselves, but they directly infringed on the rights of the voters who they represent. And the voters who they represent are majority African-American and people of color. And so we will explore those concepts further with you tonight, but that's sort of the ultimate legal conclusions that we reach in our piece.
Thanks both of you for providing that background and really just laying the groundwork for some of your legal analysis and determinations from conclusions from what happened. And so Robyn, let's just start maybe with what happened, right? Because we've heard so many different perspectives or takes on what actually took place during the expulsion or leading up to it as well. Would you mind just taking a moment to share, what did you find, or the specific circumstances to be for this expulsion, or these expulsions?
Sure. So back in early April, there was another deadly shooting that occurred at the Covenant School in Nashville that killed 3 9-year-old children and 3 adults. And that placed the scourge of gun violence back at the center of the national conversation. And it's one that hasn't retreated for years. And at that time, according to Representative Jones, Republican members barred him and other lawmakers from raising the issue about gun violence and the need for gun reform on the House floor at the Capitol. He said in an article, quote, that our mics were cut off throughout the week whenever we were trying to bring up the issue of gun violence. And Jones also, there was also a quote that he said that the speaker cut off his voting machine, and that was the first time he had ever seen that happen. My research of the facts surrounding the situation also included details like that the supermajority also restricted the key card access of some of the members. So what we saw was a situation where gun violence became front and center. The legislators who, it's their job to debate these issues and to, represent the interests of their constituents. They understood that this was an issue that their constituents greatly cared about and wanted some action done on, and they were prohibited and barred from speaking about it, much less taking any action on that front. And so Representatives Jones, Pearson, and Johnson pushed back against this. They took to the House floor in protest, and they amplified their pleas for gun control and the need for this conversation to occur in the legislative body with megaphones and chants. They led a civil demonstration that also mobilized hundreds of gun violence prevention advocates and people in the community to converge on the State House and demand action. And then once that happened is when the supermajority Republican leaders moved swiftly to divest the representatives of their committee assignments. And then they scheduled a vote for their expulsion almost immediately. The majority accused all 3 of them for, quote, disorder and bringing disorder and dishonor to the House of Representatives and disrupting the proceedings of the House. And it reached this conclusion, importantly, without any sort of formal investigation into the events surrounding the protest. And they weren't even given an opportunity to defend themselves in an ethics committee, which I think, as Andrew might touch on, was historically the practice for 2 other expulsions that had happened in Tennessee. And so the only time that they were given an opportunity to actually speak in their defense was immediately before the body took a vote on the expulsions. Ultimately, the vote was taken, and the supermajority voted to expel Representatives Jones and Pearson, who again are both African American, and then Representative Johnson survived the vote by one vote.
So Robyn, thanks for sharing that. And Andrew, I want to pick up a little bit on that, the supermajority, right? And thinking about the fact that while this was about gun violence, right, there were other issues in other states where supermajorities are making similar decisions, or we're seeing this trend across the country. While Tennessee did have a lot of attention on it, there are other notable cases across the country that are really touching on this trend a bit. Could you mind sharing a bit more about what you're seeing across the country?
Yeah, that's exactly right. And I give those 2 examples off the top in Florida and Wisconsin. And to put a finer touch on it, again, these actions are always inextricably linked up with underlying issues. In both the instance in Florida, where the elected state attorney was fired, as well as the Wisconsin justice who was threatened with impeachment. In both instances, it related to their views on abortion. And it related to the fact that they spoke out as elected officials on in a way that they thought was appropriate, and responded to the wants and needs of the people. In a similar vein, we saw an alarming instance in Montana, where a transgender lawmaker spoke out on the House floor against a bill that would ban gender-affirming care in the state. She was subsequently, as we say, effectively expelled. She wasn't actually kicked out of the legislature, but she was told she was no longer allowed to come to the floor, no longer allowed to participate in speech or debate, kicked off of committees. She reported that she had to work on benches in the hallway because they wouldn't let her go anywhere else. And it's the same issue where a party in power doesn't want to debate an issue, doesn't want to get into the weeds of something, and so they use their power to silence members of the minority. And as Robyn importantly pointed out, this then goes back to their constituents who are without representation, who are denied the political power that the Constitution promises them. And I'll just give one other quick example and wrap up there. We've seen a growth of extreme partisan gerrymandering in this country, and it's an issue cut from the same cloth. It's another way of those that currently have power finding a way to stamp out all dissent and ensure their own power at the expense of their fellow citizens. If you are not able to cast a meaningful ballot, states that don't allow their citizens to cast meaningful ballots are not in compliance with the Constitution. And it's a growing problem we're seeing of legislatures being able to really get away with that scot-free, even when, again, we all feel and can identify it as a problem.
Thanks, Andrew. And so I'm thinking about a majority in this particular instance, right? We heard from Robyn. She provided the facts and backgrounds of the circumstances in which she was able to determine through an assessment analysis, but they also provided, some justifications for this, right? There was some justification on why the decision was made to expel. Can you explain these justifications to us a bit more in detail, Robyn? And then are there any counter arguments that are presented in the article that you will be able to share with us as well?
Sure. So yes, as I was saying, the justification that the legislature provided for the expulsions and the attempted expulsion of Representative Johnson was that they essentially disrupted the proceedings of the House. And one of the things that we did make sure to mention in our article was that we do believe that under the state constitution, the Tennessee legislature does have the broad authority to expel members. But what we ultimately come away with is that power that they have expressly has limitations, and not only probably located in the state constitution also, but in the federal constitution, there are limits on the exercise of that power. And I think one of the key facts that we wanted to zero in on was the discriminatory effect of the expulsion vote. So, given the fact that the 2 African-American representatives were expelled and the white female representative was spared, many people across the nation also were roiled at the outcome and understandably, believed that represented a racist or racially discriminatory action. And so as I moved into the legal analysis, As I was stating earlier, the 14th Amendment states that no state shall deprive any person within its jurisdictions of the equal protections of the laws. And one of the things that means is that the Constitution prohibits or forbids intentional discrimination on the basis of race. And so one of the cases that the United States Supreme Court decided in 1977 was Arlington Heights versus Metropolitan Corporation. And in that case, the court devised an evidentiary framework or a test that lower courts use to determine whether a particular action by a legislature or another government actor is intentionally discriminatory. And what the court said in that case is that they recognize that it's usually plaintiffs will not have the sort of proverbial smoking gun or the kind of direct evidence of discrimination that we could think of as being, pervasive during the Jim Crow era, where a legislature will go on the record and say, we're taking this action for the express purpose of, nullifying the votes of African Americans or to make sure that an African American cannot hold an elective office. And so what the court case recognizes is that usually plaintiffs will need to come forward with circumstantial evidence that when viewed together leads to a conclusion that the action was indeed intended to be racially discriminatory. Another important aspect of this case is that the court says a plaintiff is not required to show that the action, that race discrimination was the sole purpose or was the determinative factor. They only need to show that it motivated the decision. And so under this particular case, the court assesses a number of different evidentiary factors, usually that are proven with circumstantial evidence. Three of those factors include the act's discriminatory impact, the legislative history, and the historical background. Another important feature is that the court specifically says that the discriminatory impact is very instructive in assessing whether or not the action is intentionally discriminatory. And so what Andrew and I did was we analyzed those facts that I gave at the outset of the call, and we applied them to those factors that I just listed. And we ultimately concluded that under our analysis, when viewed together, the actions that were taken were racially discriminatory and indeed would likely violate the 14th Amendment's equal protection guarantee. And then I'll pass it to Andrew because I'd like for him to talk a little bit more about the 15th Amendment violation.
Thank you.
Sure. Thank you, Robyn. So the 15th Amendment, as Robyn alluded to, prohibits racial discrimination in voting. And what this means at a practical level, when we look at a case like this, is if the way elections and representation are run and happen in a state are that voters of color have less political power, they're not able to elect the candidates of their choice, they're not able to have representation that they as a community want, we ask questions of whether the 15th Amendment was violated. And so we get into an issue here where three members of the Tennessee House who represented large communities of non-white voters see those members targeted, in two cases expelled. Again, we kind of go through that same looking under the hood, what's all the evidence here, there's not going to be smoking gun kind of analysis of whether they were denied their representation, and if so, that's a potential 15th Amendment violation.
Well, Andrew, I want to stick with you for a moment, because I think as we talk about these kind of arguments to the justifications and the power that Robyn alluded to, right? There's also this sort of checks and balances, right? That needs to take place as well. And so, but that was an interesting outcome in Montana. Can you just talk about the most recent Montana court ruling and just talk about how that ruling could actually impact precedents or differs from precedents that have been held by the Supreme Court in other similar cases?
Absolutely. So I talked about the representative of Montana who was effectively denied her ability to continue participating as a legislator. She actually brought suit. She sued the legislature itself and said what they had done violated her First Amendment freedom of speech rights, and they needed to reinstate her. The state court in Montana rejected her claim, and it gave a very, very, very short order that didn't really explain its thinking or reasoning, and basically said, this is the legislature's business. It's their decision. We're not going to get involved. And that presents a real separation of powers problem for a couple of reasons. The big one, the one I really want people to take away, one of the main jobs of courts when constitutional claims are brought to them is to protect rights that have been violated. And so there are real questions of the balance of powers that are granted to the legislature. And we'll be the first to tell you, legislatures have broad power to expel their members. It's just not unlimited. And one of the areas in which those limits come in is constitutional rights. And so the Supreme Court has said a number of times in a number of different contexts, when someone comes to court saying one of their constitutional rights has been violated, the court needs to hear the case. And it needs to be the one to make the determination. That is its role in providing a check on the other two branches of government. And it can do so when it's looking at questions of constitutional rights without violating separation of powers principles. And so that decision on Montana was disappointing because it showed that that was a court that was not willing to take up its duty to protect rights. And it was going to let the legislature potentially violate First Amendment freedom of speech rights unchecked. And we've seen some courts starting to do that more and more in a variety of different ways, and it's a real problem. So just to give one example for you, in the voting rights sphere, there's this doctrine called the Purcell Doctrine. And it's from a Supreme Court case from a handful of years ago, and really all they said in that case was when you're really close to an election, courts shouldn't change the election rules. It's just difficult for election administration. You got to print new ballots, all these things you don't think about unless you're an elections clerk. Courts have taken that inch and gone a mile. We now have cases where 9 months before an election, courts will say, Purcell, we're too close, we can't do anything. And what that says a lot of things to legislatures. One of the big things it tells them, you can pass the most unconstitutional voting law imaginable, you're probably going to get away with it for an election or two, because courts are going to throw their hands up and say, we can't deal with this, maybe we'll come back to it later. And so that's why it's so important that courts play their role and do that analysis and not let the other branches run unchecked.
So Andrew, sticking with that for a moment, right? You spoke about courts really maybe not holding up their duty, if you will, or addressing these issues or intervening. Robyn, I want to ask you, what do you think would happen, or what do you think the consequences would be if a court did intervene? How do you think that would actually play out in some of these decisions to expel legislators and other elected officials?
Thank you for the question. So I think there are a number of consequences that come from courts actually upholding their duty to say what the law is and acting as a check on other branches of government. I think one is that it may have a deterring effect on other state legislatures who, looked at the situation that happened in Tennessee and may feel that they want to emulate what those actions or to take similar actions against their members of their body. For discriminatory or invidious purposes. And so I think, as Andrew stated, it's very important for courts to recognize that they exist for the purpose of redressing constitutional wrongs. And it's the very idea of separation of powers that actually justifies the ability and duty of courts to intervene in these kinds of disputes, because the judiciary sits to tell other branches of government what the law is and what the law does and does require and what it prohibits. And when courts refuse to get engaged in these kinds of disputes, they really shirk that duty and they render the constitutional guarantees and rights meaningless. So I think the first is a deterrent effect. I think another is to tell those who do suffer violations, like the ones that we are addressing tonight, that there is a place for them to go to have their rights redressed. I think a critical aspect of our Constitution suggests that when you have a wrong, that the courts should be open and that they should be accessible to every person who feels that they have been aggrieved under the constitutional guarantees that are supposed to be guaranteed to all of us, regardless of race, regardless of background, regardless of our political views. And so I think another consequence is that the courts will re-emphasize and reinforce that they do stand as a bulwark against these kind of excesses and abuses, and that people know that individuals and citizens in this country can be assured that if they do suffer the kinds of wrongs that we're discussing, that there is a venue where they can go to have those wrongs redressed. And so I think those are the two consequences that I would say. And then the third, I think, is just related to the more narrow focus on voters. But I think it's critical that courts intervene in these disputes and that they, right these wrongs that are occurring, because it really does reinforce the concept of our democratic form of government. The will of the people is what is to take the day, and not the will of members of a legislative body. And it is from the people that those members even derive their power. And so I think that's also a really key aspect of judicial intervention into these disputes, because it reinforces that idea and principle that our democracy is founded on, which is that the will of the people is to be respected. And that when other branches of government flout that principle, it is an egregious violation of our structure of government. And again, it is one that courts sitting under the Constitution, that is their primary function, is to wade into these disputes. And one last thing I'd say, Wade, is that I think an especially pernicious thing would be for courts to actually say, yes, we have the power constitutionally to review these kinds of issues, but we don't have a way to craft a remedy. And I think that's another sort of outgrowth of this problem, is that to the extent that there are courts that recognize that they have the power to entertain these actions, you see that sometimes where there's courts that, basically prevent or restrict the ability for a remedy to be crafted. And so I think that's another aspect of this, is that our piece not only says that they have the power to review these disputes, but that they actually have the power to craft remedies in a way that fully and meaningfully redresses the wrongs.
Okay, thanks for that thoughtful response, Robyn. And Andrew, you touched on this a little bit earlier, but I do, for just the folks who are here with us this evening, I think it's still important to just understand the historical context of these expulsions, and how do they really fit right into other cases, other types of decisions that have been made with respect to elected officials. Can you share a little bit more about the historical context of these expulsions?
Of course. So as we just said in the piece, there have been 142 total legislators expelled in United States history. 20 of them were in Congress. 17 of them were for committing treason for siding with the Confederacy. At the outbreak of the Civil War, there was one other case of treason. The other two were for members who were convicted of taking bribes. Again, the legislators have broad power to expel to deal with cases like these. People who are committing treason shouldn't be representing us. People who are taking bribes shouldn't be representing us. Of the 122 instances of expulsions in state legislatures, again, the vast majority were for committing crimes or a number of instances of sexual misconduct. And then there were a handful, all over 100 years old, some dating back much farther, that I think are more in line with what we saw in Tennessee, but certainly aren't principles and examples that in the modern day we want to see our leaders living up to and exemplifying. So I mentioned this example at the top, right at the end of World War I, the New York legislature kicked out 5 members solely because they were members of the Socialist Party. And the majority in that legislature decided that was in and of itself wrong, and their associations and their beliefs made them unfit to serve. That's something that I think hasn't aged well. And the other example that I didn't mention at the top, but I'm glad I have the chance to now, is during the Reconstruction era, we're talking over 150 years ago at this point, the Georgia legislature kicked out the first 30 plus Black members elected to the body. And in that case, in fact, the Georgia Supreme Court ordered them reinstated. And so they were a bit more brazen in doing it and in explaining the racial motivations and not potentially, hiding behind pretenses. We didn't have to look into all the circumstantial evidence quite then. They were a little more open, but it still tells us that if that's the only time that's happened in our country's history, and it was literally just after the Civil War, that the fact that we're seeing something that's at least partially analogous to that is deeply, deeply concerning. And a big takeaway here is that norms are breaking down. Legislatures have always had the power to kick out members just because they didn't like them, at least to some extent. Again, it's a broad power, not an unlimited one. But the fact that we're starting to see that happen, and at least 1 or 2 instances, tells us that these norms are going away and we need additional, more formal safeguards, which again, we would look to the courts to be one of the major ones there.
Thanks, Andrew. And so I want to go to Robyn for a second, because she shared some context around why she believes that this may have been racially motivated. We also, though, know that at its core, may be just the violation of a First Amendment right and freedom of speech. And so I'd love to get your thoughts, Robyn, on how does this particular issue or these expulsions challenge or reinforce the protection of freedom of speech and political expression, especially for elected officials, because that's where, if you're an elected official, you have to ask yourself, well, what can I say? What can I say? And will I be penalized in many ways for it? So any thoughts around what the impact could be?
Yes, and that's exactly right. And so the First Amendment to the U.S. Constitution prevents the government from making any laws or, exercising any powers that they have that would have the effect of prohibiting or abridging the freedom of speech. And so one of the things that Andrew and I explored in our piece was, given that some of the facts that led up to the expulsions included that all three representatives wanted to speak out about the issue of gun violence, and they wanted to address, ways that the legislature could work to reform some of that issue. We wanted to explore whether or not the fact that they were unable to speak and that the legislature prevented any debate whatsoever on that issue tended to show that there was a First Amendment violation. So one of the Supreme Court cases that we explored was a 1966 case in Bond versus Floyd. And in that case, Julian Bond was an electee to the Georgia House of Representatives, and some may know, others may not, that Julian Bond was a prominent civil rights leader during that time. And he endorsed a statement opposing the Vietnam War. At that time, House leadership then asserted that because of his statement or his particular views that he held opposing the war, that was grounds to essentially deny him admission to the legislative body. So one important aspect of this case to remember is that it dealt with the Congress, the state legislature's power to exclude rather than to expel. So, while they are two different powers, they are related. And so we thought that this was an analogous case to the situation in Tennessee. The other reason why we thought it was similar was because the very reason that they gave bared on the views or the speech that Julian Bond otherwise held. And so in that case, the court said that the First Amendment requires that legislators be given the widest latitude to express their views on issues of policy without legal repercussions. And we believe that those principles that the court affirmed in Bond would similarly apply to the situation in Tennessee, where it appears that because of the views that Representatives Jones, Pearson, and Johnson held about guns, that then caused them to be restricted, or that speech or their views to be restricted by the legislature. And we also included in our article, as part of our analysis, an explanation that the U.S. Supreme Court actually regards as presumptively unconstitutional under the First Amendment any sort of actions that are taken to restrain the speech of individuals based on the viewpoint or the content of that speech. And so ultimately, that's what our research showed, and that's how we reached the conclusion that we did, that we think, independent of any racial discrimination that took place here, there seems to be or appears to be a clear violation of the First Amendment.
And I'll just, if I may add,
yes.
Please, I completely echo everything Robyn said. I'll just add on that freedom of speech is one of the few things that kind of all Americans have agreed upon for a long time. And it's extraordinarily important in that even if you don't agree with what someone's saying, you want to support their right to say it. And so it's really concerning when we see the majority in a state house just shutting off all discussion on a specific topic, right? The legislators themselves said whenever they tried to talk about guns, they had things like their mics were turned off. They potentially had key card access denied. They were told, you're not allowed to talk about this at all, let alone whether or not votes would occur to enact new policy. And so when you see that norm break down, and it's not just, we won't come to compromise on a policy issue, but we won't let you talk about it at all. That's where it's really important that that we see other checks and balances, such as the courts, again, I know I keep saying that, step up and reaffirm our commitment to First Amendment rights and not let them be chipped away at.
Andrew, are those the only safeguards that come to mind for you, that the courts will be that protector, if you will, of those rights?
No, I think there's a number of important safeguards that either we have or could have in place. Certainly, the legislature itself could recommit to First Amendment rights. Obviously, that would take a bit of an about face. I think federal legislation is extraordinarily important, and I won't take too much time here, but people may recall last year 2 different bills, the Freedom to Vote Act and the John R. Lewis Voting Rights Advancement Act, both came really close to passing. Congress has the authority and ability to put a lot of new safeguards in place. The Supreme Court has chipped away at the Voting Rights Act over the last 10 years. And so a lot of the protections we had are weakened. And just as a very quick overview, the Freedom to Vote Act would put in place equal rules in all states. All states would have to have 2 weeks of early voting. Partisan gerrymandering would be prohibited nationwide. There would be additional rules about campaign finance transparency, just as a couple examples. While the Voting Rights Advancement Act would restore the Voting Rights Act. It would create federal oversight of states that have histories of voting discrimination. It would make it easier for plaintiffs to win in court again on voting discrimination claims, which is something the Supreme Court has made harder and is likely about to do again in a case that comes out in a few weeks. So those are a couple of places where safeguards in place. And of course, the power of the people, the fact that there was so much attention on this, national attention, outcry was important. You hope they felt some shame, and other states that might have wanted to emulate this are feeling some shame about their potential ideas. So I don't want that to be lost either.
I think the interesting thing here is getting to that core issue of First Amendment rights. And so, race aside for a moment, right? This is one issue where people wanted to shut down the argument, or legislators want to shut down the argument. It could be other issues as well, and I think that's something that we don't talk about. But I will say this, based on some data and polling that the Tennessee Democracy Forum conducted, perspective in this matters, right? So when they polled Tennesseans, about 50% of registered voters said that they agreed, right, with or supported the decision to expel Pearson and Jones. But when you look at African-American voters, 72% disagree with this outcome. And so, I'd love for both of you just maybe to chat a bit about, because you talked about the people, how do we begin to bridge the gap, right? This gap between perspectives and approaches to some of these very important issues, and create a more inclusive environment where minority voices are indeed properly elevated.
Yeah, so I think that the results of that polling actually, I think I'd like to touch on just another aspect that's, I think is very important to understanding how we bridge the gap, is to actually reckon with the history that we have in this country of racial discrimination, segregation, and racism. And so I think, and that's not, and that's endemic to the United States, but that Tennessee is not immune from those historical ills. We know that Tennessee has an uncontroverted history of race discrimination, segregation, and slavery. And that's something that we actually know based on the comments of Representative Johnson is still with the legislature today. For example, Tennessee was the home, the birthplace of the Ku Klux Klan, which we all know to be one of the worst domestic terrorist organizations that this country has ever seen, is responsible for thousands of murders of African Americans, untold numbers. And so the corollary to that too is that just up until a couple of years ago, a bust of Nathan Bedford Forrest, who was the leader of the Klan in Tennessee, actually sat in the rotunda of the Tennessee Capitol. And that was something that African Americans had to walk past every single day, that kind of racial hostility and racism. And it was removed, I think, 2 years ago. And I believe Representative Pearson took a lead role in getting that removed. We also know that it is the place where Reverend Dr. Martin Luther King Jr. was assassinated. We know that it is one of the places that inspired the birth of the Student Nonviolent Coordinating Committee that civil rights icon John Lewis was an original member of and helped to form. And we also know that even today, as I said, that racist history is still with the legislature. In an interview that Representative Johnson gave on CNN, she actually discussed overhearing one of her colleagues say that he wished that a method of execution that he wanted to revive was hanging by a tree. And I think it's very clear to anyone that hears that that is hearkening back to, or yearning for lynching as a method of execution, which again was one of the main terroristic tools that's been used to murder African Americans in this country. And so I think when you ask about bridging the gap, I think it's important that we reckon with that history. And as I said, the history that's still with us, and that we recognize that what happened in Tennessee with regard to the expulsions cannot be divorced from that. And I think it's important that when we think about the ways that we bridge the gap or the divide across races, that we understand that that history is real, that it is something that deeply impacts African Americans, which I think might explain the distinction in the way that they thought about this, and that it's something that we really need to face and confront. And I think I can pass it to Andrew to sort of answer the tail end of that question.
Sure. And I'll try to just end this question with a little bit of hope, which is to say, so many of the ways to bridge the gap are things you've heard before, but are so important. Vote, advocate for things you care about. If you have the means or the inclination to give time, to give money, to run for office, these things are all really important, that citizens themselves step up, and it's hard work, and it's not easy, and it doesn't happen immediately, and that can be deeply disheartening. But it was groups like the SNCC and leaders like John Lewis a couple of generations ago who led that fight and who got changes like the Voting Rights Act passed. Before the Voting Rights Act was passed, the turnout gap in many states was 50-60% between white and black voters. Over the past 10-20 years, we've approached, though not quite reached, parity between them. And that's because of the really hard work they did and the determination. So bridging the gap it's difficult work. It takes all the branches of government to play their roles, to check each other, to do the right thing, but it also takes the citizens to stand up and to make them do the right thing.
Well, Andrew, sticking with that, I want to ask this last question, and want to then go to our Q&A section here from the members of the audience. And by the way, one of our members, Robyn, mentioned that it was Representative Jones that might have led the movement around the removal of the bust. But just quickly thinking about the power of the people, right? You just mentioned this grassroots approach to making change. If you're watching this right now, right, as an individual, like what are those things that you can do from whether it's grassroots, community engagement? What are those things that you would advise people to do to go in and make sure we can protect our democratic processes?
Yeah, there's a lot of them, and it starts, I'm a voting rights, so I'm always going to say this, it starts with always voting in every election for everything on the ballot. We have a lot of elections in this country, but they are ultimately really important. We talked tonight about how these representatives represent very local communities, the important role they can play and how important it is for constituents to represent it. It really can make a difference to give time you have to volunteer to causes you care about. Running for office, there's so many stories of people who just one day were fed up and decided, why not me, and became change makers and leaders. And so I would challenge everyone, if that's something you believe you can do, why not you? And call your representatives. The bills are talking about came within a couple of filibuster votes from passing last year, and they would have been truly transformative. They are landmark legislation. Elected representatives really listen to their constituents. They really want to keep their jobs, and they know you are the ones who help them do that. And many of them are passionate about these policies too. So those are all some really important ways you can be involved. And the more people who take those things on and participate in democracy, the quicker and more effective the change can be.
Yeah, I think, yes, sir. And Robyn, I was going to ask you the same question.
Yeah, I would also always obviously start with the same call to action, which is to vote in every single election up and down the ballot. And as we talked about tonight, the importance of courts, I think it's critical for voters to make sure that they engage and vote in the judicial races as well when they are on the ballot, because we understand very critically how that plays a role in protecting our democratic values. The other thing I would say too is that people should donate to groups that are taking important actions and helping those in need, or that are furthering the democratic norms and values that we've discussed tonight. Ones that don't, prohibit or not prohibited by the Constitution, but are actually furthering the guarantees that are written in it. And then finally, I would say a key thing that people can do is to promote the truth. And to dispel myths and lies whenever they appear. I think, as I stated in my previous answer, I think it's very important that, the facts are laid bare whenever we make assessments about the reach or consequences of certain actions. And I think it's important for not only leaders, but for the public to denounce any sort of lies or myths or mistruths that are floating and circulating about what happened, or about, what our Constitution guarantees, or what it means to be an American in this country, which is that everybody should have equal rights, and that those rights cannot be infringed. And I think also promoting truth means that we reckon with, as I said, our history in this country, and that we confront it in a truthful way. And, I think that's one of the main challenges of our day too, when we see elected leaders across the country, for example, in Florida, Governor DeSantis, who is trying to remove books from schools and prevent this history from being taught. So we just have to make sure that we're pushing back on those efforts. And one way to promote truth is to make sure that all history is taught, that we know our history, and that we know and recognize that the history of African Americans is American history.
Thanks, Robyn. And I want to go back to something I think both of you really talked about, which is voting, right? In terms of the importance of getting out and having I'm a huge voting rights advocate as well. But, one of the questions that came from the audience, really alluded to the fact that, it feels like our norms are shifting, right, within the country. And, is this a time to really confront the legislature, right, to make sure that this does not continue to be the case here for places like Tennessee in particular, but across the country? Just any thoughts or reactions to that comment?
Yeah, my reaction is it's absolutely the time. And I would say it's always the time to fight for democracy and the rule of law. And yes, now in particular, where we're seeing the backsliding we've been talking about all night. And I mentioned this a little bit. Shame has kind of guided a lot of public officials over the last couple of generations to stay in line with the norms. And we're seeing that go away a little bit. And so people having the strength and the courage to stand up and demand change makes a difference. And it brings the legislators back to reality, or any officials who are stepping out of line back to reality, and reminds them that the people are watching, and that in and of itself can make a difference. So yes, we should absolutely be fighting for norms to be upheld, whether it's not kicking out fellow legislators for no good reason, whether it's freedom of speech rights, whether it's fighting against discrimination instead of giving into tendencies towards it.
Yeah. Thanks. And just for either of you, but maybe I'll start with Robyn on this question. And it's going to the question around race, right? Because we spoke earlier about the justifications that were provided by the legislature on the expulsions themselves. And so what the question is really, focused on Representative Johnson. And the statement is, well, or at least some people alluded to the fact that she wasn't as disruptive, if you will, than the other two representatives. How does that square with how you approach your analysis at all when it comes to making a determination that this might have been racially motivated?
Yeah, thanks for the question. So it doesn't change our analysis in any way. I think, as I stated, that under Arlington Heights, there are various factors that courts assess to determine whether an action was intended to be racially discriminatory. And as I also stated, intended meaning motivated by race. So again, the court case says that even if it wasn't the sole factor, if it motivated the decision, then that's prohibited. So I think that's the first way I would answer it, is that, although it might not have been the only reason, that doesn't necessarily answer the legal question that we would be presented with. The second thing I would say is those statements are belied by the facts in this case, which indicate that all three members, that articles of expulsion were leveled against all three of them. So I think that just begs the question that if her conduct was somehow different or could be differentiated in a meaningful way, then why were all three of them faced with the threat of expulsion? I think the other thing that I would point to is the language that was included in those articles, which I quoted at the outset, which said that they were expelled for, quote, disorderly behavior. And so I think a key element of that is that that wasn't qualified in any way. So there wasn't anything in the express language of the expulsion articles that stated that, this was because of a certain amount of disorderly behavior, or that a certain quantum of disorderly behavior is what constitutes an expulsion. It just says disorderly. And Representative Johnson herself, indicated that she believed that they all engaged in the same or virtually similar conduct. And the other thing that she expressly said was that she thinks that race motivated the decision, and that her race was it was one of the factors that ultimately saved her from the expulsion vote. So I think that those are the sort of facts that I would look at. And those are the reasons why I would say that doesn't alter our analysis in any way. And I don't know, Andrew, if you had anything to add to that.
Yeah, I think that's spot on. The only thing I'll add is this isn't us claiming that we can see into this one person's mind or into his heart. It's looking at all the facts surrounding what happened and analyzing them in the way the Supreme Court has told us is the way we do it in order to determine whether there was an instance of racial discrimination. And when the defense against it, and I do really appreciate the question. Let me say it's an important question, and I'm glad you've given us a chance to talk about it. But when the defense against it is, a relatively minor distinction, while someone had a microphone, someone was just yelling loudly, that's not going to sweep all these other facts under the rug. It's not going to answer to the history of discrimination. It's not going to answer to the discriminatory outcome. And it's not going to answer to, as Robyn said, Representative Johnson herself indicating she thought it played a role.
So thank you both for those responses. And I think about the legislator in Montana who went right to the court to try to address or have her particular issue resolved there. And we know what happened with the state court there. But in this case, has there been any litigation that you're aware of filed around this decision to expel?
I'm not aware of any. That's obviously a decision that would be up to the representatives or perhaps any of their constituents who felt their rights under the 15th Amendment were harmed.
I'm not aware of any litigation, but I will say that at the time of the expulsions, there were elected leaders in Congress who called on the United States Department of Justice to open an investigation into the actions and the facts and circumstances surrounding the expulsions. So while I'm not aware of any litigation that's currently pending, I do know that there were calls for the United States Department of Justice to look into the situation.
Very good. Well, we're really up to the hour. I want to ask you if you have any closing thoughts in 30 seconds or so to share with the audience before we wrap up this evening.
Robyn, if you might, please, you can go first.
Sorry, I didn't hear what.
Oh, so sorry. If there were any closing thoughts, just in 30 seconds or so, that you want to leave with the audience before we wrap up for the evening.
Oh yeah, thank you. Sorry. I just want to say thank you so much again to the Tennessee Democracy Forum for having Andrew and I on tonight to discuss our findings and our piece and these important topics. And thank you, Wade, for moderating the discussion. And I think I would just close with saying that we're really grateful that we were able to write this piece. We're grateful that we are able to hopefully help guide some public understanding about what happened and to help people sort of come away with sort of like Andrew said, they knew things were wrong that happened, but they weren't exactly sure how to put their finger on it legally. So we hope that our piece does help those who read it do that. The other thing I would say is that, again, everyone on this call should vote in every election. It's very important. It is the way that we truly protect our democracy and our democratic values, and that we ensure the people who represent us do the same. And then the last thing I would say is, I think it's very important that these conversations don't stop with the conversation we had tonight. I think it's important that everybody continue the conversations that we're having. And I think as we continue to have these conversations, hopefully that will lead to a democracy where everybody can feel that they have equal political representation, where they don't feel like their voices will be squelched by legislative power, and where everyone understands and recognizes that rights do have meaning, and that when those rights are violated, that courts will intervene to redress those rights. And so I think that's where I would leave it.
I think that's fantastic. Took a lot of the words right out of my mouth.
Okay, well, awesome. Well, thank you both. Again, I just want to thank you for your insight this evening. Again, we started out talking about the fact this is not about being political. But it does involve politics. It does involve issues like around race. And so, thank you for providing again a lot of context here and for writing a very thoughtful piece, an article. We also want to thank the participants for the great questions and also for joining us this evening. Lastly, I want to take a moment to thank the team at the Tennessee Democracy Forum for helping organize this event. In the coming weeks, the Tennessee Democracy Forum will actually be announcing more conversations on democracy. So, Robyn, your question or suggestion that these conversations continue has already been granted, right? So there will be including a couple of in-person events across Tennessee this fall. We strongly encourage members of the audience and each and every one of you to remain engaged and take part in these conversations. Just stay tuned. You can connect with Tennessee Democracy Forum on a number of different platforms, whether it's Facebook or Twitter at TND Forum. TND Forum. Let's continue to listen, learn, and take action together. Our panelists today inspired us and encouraged us to do that. We know that by working collaboratively, we can play a positive role. We can create positive change and foster a more inclusive and representative pro-democracy movement. Thank you again for your participation, and I wish you all a good night.